Testimony will not begin until next month in the murder trial of Ray Tensing, but one key question looms. Will he take the stand in his own defense? 9 on your side's Tom McKee tracked down the pros and cons from people in the know.
There's no clear indication tonight whether defense attorney Stu Matthews will allow his client Ray Tensing to take the stand and tell jurors what happened when Sam DuBose was shot. Experts I've talked with say there are good reasons to do it and good reasons not to do it. Tensing is charged with murder and voluntary manslaughter for the July 2015 shooting after a Mount Auburn traffic stop. Criminal defense attorney Merlyn Shiverdecker says the general rule of thumb is not to put a client on the stand.
Typically, most defendants do not help themselves when they take the stand. Inevitably, most of the time, they harm themselves when they take the stand.
Tensing's attorney has said his client was being dragged and feared for his life when he shot. That would be up to the defense to prove.
It often does require the defendant to take the stand and tell that jury, I was in fear of my life. This is why I pulled the trigger. This is why I shot that person, because I was afraid that I was going to die.
But there's risk in doing that.
If the defendant is a bad witness, the prosecutor will often just eat him up and spit him out.
Here's a timetable of how the trial will play out. Jurors begin to fill out questionnaires Tuesday. Then the prosecution and defense will study them the rest of the week before starting direct examination of those jurors next week. Testimony is not likely to begin until Monday, November 7th. Tom McKee, 9 on your side at the Hamilton County Courthouse.